Hello, it's good to know you are there again. Welcome to Bring It On. I am Ambrose Ezewani. As usual, we are here to discuss what touches all of us as a people, as a nation. Today, we're looking at the proposed or recommended removal of the immunity clause from our Constitution as it concerns the governors. What it means, in simple terms, is that while in office, that's as at now, anything done by governors might not lead to taking their case to court. In simple terms, they are protected while in office. But outside the office, in other words, when they step down, that case can be taken up. Now, the Justice Belgore Commission or Committee are tasked with amending our Constitution, that's the 1999 Constitution, has come up with some recommendations. And one of them is that that protection, i.e. the immunity that the governors get while in office, should be removed. In other words, if they do anything wrong while in office, they can be taken up legally. And as expected, the 36 governors have met, and they're making strong representations to leave things the way they are. In other words, they are opposed to the removal of that clause from the Constitution. And that's what we're discussing today. And my guest here is Ladipo Johnson. He's a legal practitioner and also a politician. Welcome to Bring It On.
Thank you very much.
Immunity clause. I hope my explanation is right, the way I describe it in layman's language.
Yes, the Constitution provides for the fact that the executives, in this case we're talking about the president and the executive governors, that they will be protected from prosecution during their tenure in office. For various reasons. It doesn't stipulate the reasons, but if you look at other jurisdictions and the way our Constitution came about, you will see that the immunity clause is not there for the Senate President, it's not there for the Speaker of the House, but it's there for the executive arm of government, not the local government level. The executives at times will have to do certain things. They envisage that they may have to do certain things that ordinarily may cause people to want to prosecute them, take them to court. They may have to do certain things on behalf of the country or on behalf of the state. You understand?
And that would lead people to say,
exactly.
Why did you do this? Come on, this
yes. So that, I think, is part of the origin of the immunity clause being included in the Nigerian Constitution. It was in the 1979 Constitution as well.
Yeah.
And it found its way into
the 1999
Constitution.
Is it a general provision for governments all over the world, or is selective? Take the UK, for example.
In most jurisdictions, you understand, in most jurisdictions, it is. Okay. In some jurisdictions, it covers certain aspects. For instance, the recent example of this we can get is the fact that the erstwhile Italian Prime Minister Berlusconi faced a lot of court cases, either for libel and what have you, or in fact relating to his relationship with an underage prostitute or what have you. So then you move to jurisdictions like the United States. There it is very, very strong. The presidency is very, very well protected, and due to the fact that you can imagine with the U.S., he's the policeman of the world. he has to be protected. Yes.
Okay, let's bring it home now,
Yeah.
because we're talking of our constitution. As you rightly said, the Belgorod Committee might be thinking of the peculiar problems we have in our country.
In Nigeria, yeah.
Now, looking at it from that perspective, it's not proper to say, yes, let these people sit up, let them know that people are watching and they can be questioned. So is it not proper to say, yes, let the immunity clause go?
Well, I think that we can't rush. I would urge caution. You understand? There is a system in place already, if it were being followed.
And that when somebody that is actually under immunity leaves government and there is no seriousness in prosecuting him, he enters into the Senate as a senator of the Federal Republic of Nigeria, whereas he has a criminal charge hanging over his neck. And that's why people are saying, well, let us not waste time waiting until 8 years before he leaves power, before you begin to prosecute him. Begin to do that even while he's in government. But then what is the intention of the framers of the Constitution in including issue of immunity clause in the law book? What was their intention? What was the mischief that they wanted to cure in doing that? And I say that it was issue of distraction. That if somebody is a governor, if somebody is a president, he should not be distracted while doing the business of governance. He should be given all the required opportunity to give people good evidence of democracy. That if you have all these cases hanging over his neck, you drag him to court today, drag him tomorrow, the man will tell you after the 4 years tenure that, look, I had no opportunity to really concentrate. That's why I couldn't do anything whatsoever. And so the law now came and said, give them immunity within the time they are in governance. When they leave out of government, if there is anything that they have committed, then go after them. So, but the abuse in the system now have made people now to begin to look at that law and say, is it worth it in the first place? But my question is, who will be the ones again to try them?
That's the question.
Who will be the ones again to prosecute them? The same set of prosecutors, the same set of judiciary that will also handle it. You find out that time is being wasted. Why don't you advise building up strong institutions and let institutions be performing their duty? That if somebody is a governor today, for 4 years, he leaves government and he has committed any corruption case, you go after him and get him convicted within a short possible time, the way Ibori's matter was handled within a year. Ibori's matter started in April last year, remember? Yeah. And this year, April, there was a conviction and he's now in jail in Britain. But your own takes over 5 years, 6 years, because the matter here is that you begin to even argue over preliminary matters. He's a lawyer. You don't even go into the substantive case. You know what lawyers are doing? If a man is charged, a political exposed elite is charged for anything corruption, they come with issue of jurisdiction. And so when the court says, I have jurisdiction, they go on appeal.
Just to support what you've said regarding strengthening of institutions, if you're prosecuting him when he is still governor,
yes.
It even gives him more power to make sure that pressure is brought on the police, or if it's the EFCC or the judiciary. You understand? He is still, at that time, the executive governor. Okay. So it makes it even more difficult to achieve that speedy trial that we're talking about, or fair trial for that matter. Okay. But when he no longer wields such influence, it's easier.
You have your day in court. If the system works.
If the system works. Okay, so we should be looking at perfecting the system first before the Constitution.
Let me just tell you why people even say they want to take laws into their hand. You know, when, like what happened in Edo State, remember that at the time ACN were saying, look, if the police cannot do it, they will take laws. If the police is functional, if they're working and a crime has been committed and somebody will be caught and somebody will be prosecuted, there is no question of somebody threatening that will be a reprisal attack. That won't be a need for that. You don't allow people to take laws into their hand. There are institutions that are supposed to work perfectly, in accordance with the law, in order to ensure that society feel confidence that those institutions will get the culprit and punish him. But when there is a failure of those institutions, that is when people now have a resort to issue of self-help and you hear issue of reprisal attack and all that. I think we should at this point in time, begin to build our institutions and allow them to work independently. And then let there be also monitoring the institutions that are also working. Because when you set up an institution, you don't allow them to be self-serving. There must be an institution also watching. There will be another institution watching the one that is watching. That is where it's been done.
And the Senate and National Assembly will perform their oversight.
And then we will be now, even at the background, the people, because power resides with us.